Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, what happens if my spouse is wasting or spending the marital assets that we will be dividing in the divorce?
So one of the concerns that we sometimes hear when meeting with or consulting with new divorce clients is that the client cannot or says that he or she cannot stop the soon-to-be ex-spouse from spending assets or otherwise wasting assets or somehow depleting the marital estate. And the concern is that ultimately there will be obviously less to divide at the end of the case. This is called dissipation of the marital estate. And there's very specific case law in Connecticut on the subject. So the first question to ask is whether the spending or the dissipation is occurring now, that is, while the divorce action is pending, or whether this is something that happened a while ago, or both. Spending that's happening now would be governed by the automatic orders. And these are orders which apply to all pending divorce actions in Connecticut. These orders are served along with the initial papers in a case, and they direct the parties not to transfer, remove, or otherwise encumber marital assets during the divorce. So basically, they direct the parties to maintain the status quo with respect to the assets and the normal spending patterns and habits of the family. This does not constitute a freeze on assets. Rather, it means that everything should happen the same way it has been happening. And that includes typical spending patterns, typical credit card spending, typical bill spending, those kinds of things in the ordinary course of business. In the event that money is being spent or assets are being depleted at an alarming rate or for an improper purpose, that could by itself constitute a basis for a motion for contempt for failure to follow the automatic orders. That's something that can be filed during a case, and the court in that particular case would have the authority to compel compliance with the automatic orders and to punish parties accordingly for not complying. The punishment could include immediate orders of compliance. It could include some kind of a financial sanction. It could include attorney's fees as well. But if the spending or the depletion took place before the action started, that's a different question. So the test in that particular instance is for a court to decide that the marital estate has been dissipated and the spouse who was doing it was found to have been acting in bad faith at the time, in some way with an intent to deprive the other spouse of marital assets. And there has to be some evidence of willful misconduct of some kind. At the very least, there has to be what the court looks for is called financial misconduct, intentional waste, or a selfish financial impropriety, coupled with a purpose unrelated to the marriage. In other words, if the spending is happening for a reason that's related to the marriage itself while the parties are married, that's not likely to be found to be a dissipation of the marital estate. The temporal scope is important as well. For it to be dissipation, the court will be looking for evidence that the conduct in question would have to be at a time when the marriage was in jeopardy. In other words, that temporal part ties in with the intent piece that I talked about earlier. There needs to be some kind of intent to deprive the other party of property in an act or a manner contrary to the interest of the stakeholders, both stakeholders to the marital estate. By way of example, gambling debts, spending on illegal drugs, transferring property out of the estate to either a relative or a friend without the other party knowing, those may be examples of dissipation. But for example, a poor investment decision, even one that was supported more by one spouse than the other, that's unlikely to be considered dissipation of the marital estate. If you have any questions about an alarming spend down of the marital estate, either during the divorce action or in the years prior to a divorce action, it's best to confidentially discuss the situation with an experienced family law attorney regarding your options. Thank you.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.